Good morning. Riley with Chronicles of Liberty. Video number 18, the supreme law of the land. And I think this is where it all hinges, right? This is the pinnacle of who we are as a people and who we are as a country. And in the United States, the supreme law of the land is the United States Constitution. It was written after the Articles of Confederation were found inadequate. This document supersedes all the rest of the government and determines how much power they have. In fact, in most state constitutions, if not all, they recognize the U.S. Constitution as the supreme law of the land, generally in their preamble. And even though each state operates independently, we can all recognize that the document which guarantees us, the people, protection of our God-given rights, from the very beginning, it says, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Article 6 says of this Constitution, establish the supremacy clause. And it says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, and anything in the constitutional or laws of any state to the contrary notwithstanding." Okay, so first, notice the things that Article 6 lists as the supreme law of the land. The Constitution, the laws of the United States made in pursuance of the Constitution, and treaties made under the authority of the United States. What we don't read in Article 6 are Supreme Court opinions. In fact, Thomas Jefferson said it very well. "On every question of construction, let us carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, and instead of trying what meaning may be squeezed out of the text or invented against it, conform to the probability on which it was passed." There is an ancient legal maxim that reads, "Expressum facit cessare tacitum." Translated into English, it reads, "What is expressed makes what is implied silent." This means if the founders had intended to include Supreme Court opinions in the list of those things that make up the supreme law of the land, they would have done so. Guess what? They didn't. The supremacy clause also does not declare that all laws passed by the federal government are the supreme law of the land. A closer reading reveals that it declares that the laws of the United States made in pursuance of the Constitution are the supreme law of the land. What does pursuance mean? In the 1828 Webster Dictionary, it defines it as such: a following, prosecution, process, or continued exertion to reach or accomplish something, as in pursuance of the main design. Meaning, if it doesn't follow the initial design or intent, it isn't in pursuance. So we have to keep things in context. It's the context, people. It's all about the context. It's all about the timing in which these things were written. As an example, in pursuance thereof, not in violation thereof, any act of the federal government not permissible under any enumerated power given to Congress in the Constitution is not made in pursuance of the Constitution. Therefore, it is not the supreme law of the land and may be declared null and void by the states. So if these things are happening, are not being held to the firm standard of the Constitution, they are null and void as laws. They are not. As Alexander Hamilton clearly explained in the Federalist 78, there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. So what do we have today? We have thousands and thousands and thousands of laws, executive orders that are neither in pursuance of the Constitution or legally binding. They are void. Sadly, we just follow along as a people. And worse, we have police, sheriffs, and lawyers who don't care and don't want to have to make hard decisions about, is this in pursuance of the Constitution? And I'm not a nutcase, but our Constitution has 7 articles. And after the Convention of States in 1787, we added 27 amendments. It's pretty easy to read, people. It's a very small book. It's very easy for our sheriffs to read, our police to read, our military to read. Read it. More importantly should be that our law enforcement officers read it every freaking time they have a question about the validity and the tenacity of a law, whether it's in pursuance, if it's fulfilling and following the intent of the Constitution or not. In the old days, the sheriff was recognized as the law, right? That's what he was called. His job was to identify whether all these laws passed are null and void or whether they are in pursuance of the Constitution, whether they are legally binding or not. And this is what we've got to get back to. We've got to get back to people that are going to hold the standard of all of these things. And most importantly, you people that swore an oath to the Constitution, you should know it. And you should understand it. And you should validate whether the laws are in pursuance. That's all I have to say about the supreme law of the land. It's what it's all about, people.